Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you.
Thank you very much. And with that, I will introduce our speakers. First up, we have Andie Fields. Andie Fields is litigator focusing on employee rights in both the individual and representative capacity. Andie's practice focuses on women's rights, specifically sexual harassment, discrimination, retaliation, and equal pay. Andie takes pride in providing legal and emotional support to her clients. Andie creates an environment of trust and compassion for her clients during their darkest days. Her passion for employees' rights pushes her to work tirelessly for her clients. For example, Andie served as plaintiff's counsel in McCracken versus Riot Games, equal pay and gender discrimination class action that settled for $100 million with robust pragmatic relief. Super Lawyers has recognized Andie as a Rising Star honoree each year from 2021 to 2025. Andie is committed to giving back to the community. As a leader in the legal field, she has been the chair of Labor and Employment Law Section of the Beverly Hills Bar Association from October 2023 to October 2026. She's also a member of the California Employment Lawyers Association, CALA, as well as CAOC. Andie graduated from Southwestern Law School and the University of California, Davis. And in her spare time, she's an avid reader and loves to kayak. Next, we have Eric Schwettmann. He is a partner with the Encino law firm of Ballard, Rosenberg, Golper, and Savitt, LLP, and practices exclusively in the area of labor and employment law on behalf of management. His primary practice involves the defense of all types of employment-related lawsuits through inception, litigation, and trial. He also regularly provides counsel to employers regarding day-to-day personnel management decisions, complaint investigations, best policies and practices, and compliance with state and federal law. He is also highly versed in e-discovery related issues, having been a significant contributor in the drafting of the 2009 California Electronic Discovery Act. He represents employers ranging from large nationwide corporations to those with only a few employees. He focuses on matters involving the Fair Employment and Housing Act, whistleblower retaliation, discrimination, harassment, retaliation, wage and hour violations, and all related claims for private employers and public entities before governmental agencies and in state and federal court. Last but not least, I have our mediator for today, MyKhanh Shelton. With over 25 years of experience as a litigator, in-house employment lawyer, and senior executive at Fortune 500 companies, MyKhanh brings a unique blend of legal acumen, practical business insight, conflict resolution experience, and emotional intelligence to her full-time employment mediation practice. She began her legal career as a litigator at Quinn Emanuel, where she saw firsthand how traditional courtroom battles often failed to address the deeper human and organizational issues at the heart of the dispute. This insight led her to pivot in-house, where she spent over a decade at Fox Litigation and mediating hundreds of disputes and handling high-profile and high-stake matters in film, television, and sports industries. These experiences not only solidified her belief in the power of mediation to resolve conflicts, but also revealed the potential for mediation to transform people and organizations. As Senior Vice President of Diversity, Equity, and Inclusion at both 20th Century Fox and Warner Media, MyKhanh led impactful diversity initiatives and facilitated dialogue between management and internal and external groups. She trained executives, employees, and production teams in practices such as active listening, recognizing bias, communicating across differences. And these tools she now brings into her mediation table with equal impact at ADR Services, Inc. And with that, I will hand it over to MyKhanh.
Great. Thank you. Thank you, Anna. And thank you, Andie and Eric, for being a part of this presentation. I hope it is informative and entertaining and educational for everybody who has joined us. All right. So let me tell you, actually, okay, Andie and Eric are going to go dark for a second and Eric just literally went dark for a second. But okay. So let me tell you about the case we're mediating today and a bit about my approach to mediation. And then we're going to get into the mock mediation part of this, where Andie will come on and we'll do a private caucus. And then Eric and I will do a private caucus. And we're going to simulate as much as we can, sometimes 8 to 12 hour full day mediation in the span of the hour we have together. So starting with this case that we are working through today, it's a pre-litigation employment case. Chelsea Marotti is Andie's client. She's a high-performing MBA graduate and software engineer at a fast-growing AI company. She was heavily recruited, one of the first 5 at the company, and one of just a handful of women working at the company. Early on and throughout the 2 years that she's been there, she has been thriving. But after a company event, Dean, who is a star programmer at the company, sent her some flirtatious texts. She brushed them off, trying to keep things professional, but then a few minutes later, he sent her an explicit photo of himself. Chelsea reported this to the company. They brought in an outside investigator. The company claims they did a thorough investigation and took appropriate and remedial action, which was to verbally counsel Dean. Chelsea felt the process gave him the benefit of the doubt and not her. And in the weeks that followed, she started getting left off projects and meetings. Her performance was questioned, and she eventually went out on an unpaid leave of absence. Technically, she's still employed and on that leave of absence, but the company not sure they want her back, and she's not sure if she wants to come back. Both sides say they want closure, but they're very far apart. And so in my practice, when I prepare for mediation, I like to have pre-mediation calls with the attorneys. So after I get the briefs and I know about the case, then I get on the phone with each attorney, not to discuss the facts and not to discuss the substance of what's in the brief. Those are things we will do in session. But really on those calls beforehand, I'm trying to understand and trying to give the attorneys a chance to tell me about the client dynamics and what each side needs from me in the room, or what do their clients need from the process to bring us to closure. Sometimes attorneys tell me that they need help managing expectations, or other times they tell me that, you know what, their clients are going to need to see them fight for them. And so even though, the attorney knows this is meant to be a collaborative process, give them a chance to really, fight and state the case for their client. And that would be cathartic for them. Those are the types of things that I want to understand so I can do my best to work with the attorney to set the stage for a productive day. And then when I open, I explain my role and my background mostly to the clients, speaking directly to the clients at that point. It gives us a chance to settle in. Sometimes parties come in very nervous, and just to have a moment to get to know each other really helps people calm into the process, really change their mindset, understand that this is meant to be a collaborative process that is different from the fight that they're going to proceed with if we don't come to a resolution. So my introduction would look something like a shorter version of what Anna shared with you. I would let the parties know that I have been an attorney for more than 27 years. I tailor my introduction depending on what the attorneys have told me that the clients need. If they need to hear credentials, I will build up the credentials. If they need to hear my sense of empathy, I will build upon that. And that is also part of the preparation that we do. I do think it's important, and I have found it very helpful for clients to know that as an in-house counsel, I bring very pragmatic business sense. As a DEI executive, I bring a deep understanding of bias, not just in the workplace, but in the legal system too. And when it comes to the legal system, I point out that judges, juries, and arbitrators, they make decisions about the case that's in front of them. The case that right here is affecting the life and livelihood and the future of the parties, based on the assumptions and the background and experience that those judges and juries have, based on their own lives, more so than on the lives and on the business that is in front of us in the particular case. And so I became a mediator so that I could help the parties make decisions for themselves and not leave these major decisions about the party's future in the hands of strangers that have biases. And so I say that's what we're going to do together today. We're going to put aside the fight. We're going to work together to get the best deal we can on the table so that by the end of the day, the parties with their attorneys have the opportunity to make their own decision about how they want to proceed. In this mock mediation, you're not going to see a ton of back and forth on numbers, and that's by design, right? I mean, you can imagine what happens when we're negotiating the numbers. For the most part, I try to streamline that process because it is fatiguing and sometimes really frustrating to just do incremental back and forth. So in terms of my approach, I do try to streamline that quite a bit. And in terms of this mock mediation, you'll understand that we're compressing, 8 hours into this short period of time. So imagine the time lapse. I will cue you so that you understand that we've had a lot of discussion. There's a lot of work. There's a lot of work that I understand that the attorneys do with their clients. There's a lot of work that I do with the attorneys together with their client and sometimes in private caucus with just the attorneys. That's what you're going to see today, me working directly with each attorney. All right. And then early on, you'll see that we're spending time building rapport. We're understanding the party's interests. I'm not pushing on the numbers a whole lot in the morning. That happens throughout the day. And then by the end of the day, we've gained momentum and things start to click into place. So let's get started. And I typically start in plaintiff's room. So I will start there and bring Andie into the room. Hi, Andie.
Hi, MyKhanh. How are you?
Good. How are you doing?
Good.
And how is Chelsea?
Chelsea's good. She's ready.
All
She's
right. Well, thank you for your brief. It was very thorough. It gave me a very good sense of how you all see the case and how you would proceed if you were to file and you were actually going to prosecute this. So thank you very much for that. I want to know from you, there are a lot of questions that I have, but where would you like to start? Where do you think would be important for us to focus today?
I'd like to start with who's in the other room. And do they have an insurance carrier here? We're in pre-litigation. I'd like to know if they do have insurance and if they have an insurance carrier in the room or on the phone.
They don't. They're self-funded. They're here. The right decision makers are in the room with Eric. And so it's him and his client reps, the general counsel, who is a very experienced attorney and has been with them for since their founding.
Got it. Well, there's a couple of things that I'd like to start with. Now that you've had a chance to talk to my client a little bit, you can obviously tell that she's an articulate woman. She speaks very clearly. Her story hasn't changed. And I think that she would make a great witness. Obviously, you'll get plenty of time to talk to her today and to see that for yourself. But there's a couple of points that I want to go over. I know you've read our brief. And so there's a few things that I want to highlight to kind of streamline this. So I want to start off with she's one of 5 female employees in this whole company, right? And coincidentally, she was also employee hire number 5. As you know, and as it was stated in our brief, she was highly recruited for this position. She's very talented, very smart, very skilled, and has done an amazing job for this company and helped this company earn a lot of money, especially considering that this is, still technically startup, even though it's been going for quite some time. Startups take a really long time to build their foundation, and she's been instrumental in that. So, that's something really important. There's only 5 employees. There's never been more than 10. Sorry, there's only 5 female employees, and there's never been more than 10 female employees for the entire duration that she's worked here. So I think that that's important to note that there really isn't a large female representation in this company. I want to talk about the investigation. I understand from our, pre-mediation call that, they've done an investigation. They brought someone in. They believe it's unbiased. They believe that it was thorough and that they've done their, corrective remedial action, whatever they claim that that is, that's fine. Obviously, we don't have that. We would get that in discovery, but this is pre-litigation. We don't have that. I think that one of the things that I'd like to focus on is how she was retaliated against after this investigation. I think that she was absolutely set up for failure. Any claim that they have that she claim to be overworked, overwhelmed, is them repeatedly choosing to protect this predator over her. She was not included in meetings, and that was foisted upon her. That wasn't per request. She's never had any write-ups. She's never had any poor performance. She's been there for a little over 2 years. Now, all of a sudden, after this complaint and this investigation, now she's too overwhelmed, she's too overworked, and she's the one asking not to be included in meetings, not to be assigned to projects and removed from projects. I mean, pushing that on her is just not a believable argument. And it also shows that they are just banding behind Dean. This is really just a classic boys club, and they are supporting him. And I know that you received our declarations that were not part of the brief. I think that what you'll see, we're going to call him for today John Doe, but what you'll see from John Doe's declaration, he sits 2 cubicles away from Chelsea. He's seen Dean come to her desk. He's seen Dean continuously bother her. He's seen Chelsea be removed from meetings. He's seen Chelsea be removed from assignments, and he's willing to talk about it. I also think it's really important that we talk about Sarah's declaration. You know, Sarah was hired as one of the first, I believe, 10 employees at the company. And she also had a similar, not the same, but a similar situation with Dean, where he repeatedly flirted with her, he made advances, and sent her sexually explicit texts. They weren't pictures like we have in our situation, but they were sexually explicit, and the same excuse. They were meant for his wife. She complained to HR. The situation became so untenable that Sarah left the company. I think this is a big problem for AIT, and I think that AIT needs to recognize that they are protecting a predator and not supporting victims when they come forward. And that's a big deal. I also want to talk about the fact that we're here in good faith today. I've explained to my client how pre-litigation is a great opportunity. However, she does understand that if we can't get fair value, she's ready to file. We're ready to go to trial. We have a complaint drafted. We'll file tomorrow if they are not willing to be here and to put money on the table. We're here for that. We're ready. She's ready. However, that being said, we're here in good faith today. We would like to be able to settle. She understands the ramifications of filing, public, everything. She gets that. However, you know, I think Jen needs to know that we're serious about being today, but that if they are and it's not a good look for them. And I think one other thing that I know I attached a little bit of this in the mediation brief, but I just kind of want to touch on the fact that, you know, since the incident with Dean, my client's been in therapy, and the therapy records are really positive for my client. It shows that the retaliatory conduct that the company has done against her has really taken a toll on her. She was a rising star, and now she has been severely set back. You know, is a very small, close community. This could be very detrimental for her. So those are the kind of things that I wanted to highlight for you, and I'm happy to answer any questions, obviously.
Okay. Thank you, Andie, and I'm glad to know she is in such good hands with you. But let's see if we can try to get this resolved so she can put this behind her. Let me ask you about the declarations. You'd mentioned that you wanted to keep them confidential. So I want to talk to you about how we can use this information, how you want to disclose the declarations. You already know, you can imagine that Eric is going to put as much value into it based on how much you're willing to share, right? I mean, we can expect that they're going to really not put too much value in it if you don't let them know who it is, let them have a chance to, you know, get into the credibility of those declarants. So what are your thoughts on that?
Yeah, so I think at this point, right, we can only give as much as we're going to get. And I think that at this point, there's been no mutual exchange of documents. That wasn't something that had come up between Eric and I before getting into this mediation and agreeing to come here. So I think right now the confidentiality of the individuals is important. However, I think the content should be shared with discretion. Obviously, John Doe is in fact still a current employee, and we'd like to do our best to prevent retaliation for him as well. And so I think that conveying the seriousness of the declarations and the fact that the company was on notice about Dean's behavior beforehand with Sarah's declaration, and that there are witnesses willing to support Chelsea's claim and support that the conduct after the investigation was in fact retaliatory, can be very valuable without the names and identifiers.
Okay. Okay, great. I will share it in that context. I think it's really smart of you to have advised Chelsea to come into mediation early, pre-litigation, when she has the most options in terms of her career and her future and how to proceed with this. I understand that it affects how much information exchange we are going to need to do throughout the day and how you all value the case. What are you thinking at this point in terms of an opening?
Yeah, so, as you know, me and my firm, we can be aggressive, but we're really here for our clients, and we don't do anything without our clients' explicit approval. And we're here to do what's best for Chelsea, and Chelsea knows that. And so I kind of wanted to get your take on it. We need to start in the seven figures. I'm thinking somewhere between 2 and 3, maybe something maybe around 2.5, but kind of wanted to get your take, your feel on that, especially taking the temperature in the other room.
Yeah. I think that's a good start. Let's start there. A lot of times I'm telling the parties, let's gain some momentum. Let's get to later day numbers as early as we can, and then see where we need to stretch. So let's start with 2.5.
Sounds good.
All right, thank you. Sit tight.
Okay.
All right, Eric, I'm bringing you in.
Hey, MyKhanh, how you doing?
Good. How are you doing?
Great. Nice to work with you again.
Nice to work with you. How
I
are you
apologize.
doing?
I got the memo about blue clothing, and I, of course, ignored it because that's where I would start the day off by noting that I went exactly the opposite with the men in black as opposed to the blue unis that you had suggested, but I just couldn't do it. Sorry out of the box.
You know what? Hopefully, I'm exuding peace and collaboration with my blue, and so you're going to get it right here in the room. How is Dean? How's everyone holding up on your end?
They're fine. They're confident in their defense. They understand that a mistake was made, and he took full ownership of it. He was credible and honest in his explanation for this unfortunate off-duty one-time incident both of them in a relatively happy hour stupor one might say. The company is very strong on its organizational structure, and he is not a supervisor. He does not have any authority over her. He doesn't really even work with her that much. They're kind of laterally based in the company structure. Neither one of them can hire, fire, supervise, manage, evaluate, anything like that. And they feel very strongly that therefore it's not strict liability, but it's should have known and did not take, once known, should have taken immediate remedial action. They believe that they complied with that in full. They believe that while unfortunate, the incident was relatively sophomoric and fraternity house behavior, they don't condone it. And they made it clear to him in no uncertain terms that any further discretions of any kind, accidental or not, after hours or not, coworker or not, sent to my wife or not, or to his dog, are never going to fly. And he will be severely disciplined, and if not fired. They did not feel it was anything further needed based on the results of the investigation, which was done at the direction of the general counsel by a third-party investigator. And they interviewed everybody who would cooperate. They interviewed everybody who somebody mentioned might know something, have seen something, heard something. And it came up with this as a one-time, one-off, real error in judgment. So they're feeling pretty confident in the liability portion of the case. For damages, since we're pre-litigation, the best they can do is figure out that since she's been on the leave, what that might look like. We don't know if she's treated. We don't know if she has any emotional distress. We don't know the extent of it. We don't know if she's actually looking for a new job or not. We don't have any real information on that, but we expected that coming in. You know, they've evaluated the case in a good faith, reasonable way as to what they're willing to do based upon the story they've been told through by Chelsea and the investigation. So, you know, there's a lot of what ifs. And so obviously we would ask to start, you know, is she treating? Is she interested in staying, leaving? They've offered her the ability to come back and she has not responded. She lawyered up with Miss Fields, and all the communications kind of then focused on the best interest of everybody as we could see it, which was having a productive discussion. I have an energy saver light in my office, and so I'm very environmentally conscious, and so my lights
thanks you. Yes.
So I apologize for that. It can't see me when I'm sitting at my desk, so it turns off every 10 minutes or so. So
well, let me answer some of these questions, and then can I ask you some questions? Okay. So
Absolutely.
She is treating. She has been treating. I think you can expect that the medical records on that are going to corroborate that this had a really, really detrimental effect on her. I mean, this was somebody who was very high achieving, very high performing, and her career has been her life. And now she has been forced to take a leave, is what they're saying, right? I'm sharing with you what they're telling me. So she is treating. The medical records are going to bear that out. Can I just ask you a few questions here so that I can understand and figure out how we, frame up your perspective, your client's perspective on this to the other side? Because obviously they see this totally differently, right? They see that there has been so little accountability taken. They actually see that yes, he agrees and takes ownership, because how could he not, that the text was sent. But the fact that he is saying that that was a mistake and it was meant for his wife and not for Chelsea is, I think, where the conflict lies, and where, Chelsea is having so much heartache around this. And so I'm just sharing with you how they're reading the case and what is just such a, offense over there. Okay. So I understand that they're saying, hey, it's not like he's saying he didn't send it, but I just want to pause on that accountability part, because that's something that I think is going to be really important for both sides to think about. Do you have any more information about what he said about this being to his wife or not, or their version that this was meant for Chelsea?
Well, did you read the rest of the text thread of that evening between Chelsea and Dean? Did they provide that information?
They did. So it was friendly. They all had fun. They were all drinking, and the end.
And did he show the picture? Did he send the text? Did they tell you about the text that Dean had with his wife, where he was telling her what he had done and was mortified and admitting to his wife that he had made this mistake?
No. Is that a part of the investigation record? Is that a part of the report?
Yes, because when you look at in the full context of the texts, there's a long thread between Chelsea and Dean, which has to be taken into consideration. We think that it could be interpreted in a variety of different ways and needs to be looked at, not just the end of it, but what happens after, when they continue to communicate before she complains, and what happens before. So that's really important. The text between his wife and him was part of the investigation, which has not been disclosed yet because we're pre-litigation, and we don't feel any particular need to share that with them, or really anything more than our brief contained, unless there's some amount of, they're going to share some things with us. So I'm not going to stick my neck out and offer up the privileged investigation at this stage. We might share some of it depending on how the facts play out and how it sort of evolves over the course of the day. That was a very long 3 hours that I spent sitting here waiting for you to come back. So I assume that there was a lot discussed, and as it always is, and we didn't exchange briefs, as we rarely do. So we don't know what their big pitch here is, but the company has a lot of competing reasons that don't involve Chelsea or Dean to be here. And that is really 85% of why we're here. They'd like to resolve this and move on and get everybody back to work harmoniously and ensure it doesn't happen again. But there's a lot of other things that are driving my client's decision-making process that don't really relate to Chelsea in any way. And she probably doesn't know and probably won't know because it's not part of anything that would be discoverable, but it's part of a general global business growth sense. The company is trying to grow rapidly and aggressively in this very competitive space. And quite frankly, Chelsea has sort of maxed out and she wasn't keeping up and she was not able to sort of pick up the performance to like a level 13. She was a solid performer. She was highly recruited, you know, and we knew everything about her background. She was fully vetted. She was an early employee. The company has had a history of having almost half of its employees be, not close to half of its employees be female, but as they've grown and they're hiring like crazy, the numbers have kind of trended down towards the females. But it's not because we're not hiring females, it's just because they're not the people they need and want for sort of phase 2 of the growth of this basically startup are different than the ones they started with.
Okay, so I think there's a lot for us to unpack there, but one thing that I did hear from you is that there are the legal considerations, but there are also business and optics considerations, and we should all take that into account because that is it's a very tricky story to tell, that this very high achieving, very high performing woman who had no problems before, after this event, started having performance problems, and somehow they're unrelated to the fact that she brought this complaint. It's going to be a difficult story, and that's how they're valuing it in the other room, right? They know that that's going to be a story that people might find hard to believe. So I get your legal defenses. I think we can talk about that a little bit more. Thank you for bringing up the fact that there are business considerations and optics. That does very often, in my mind, drive a lot of it if we can surface what those interests are and figure out how to achieve those business interests.
Well, keep in mind also that her boss, who is a manager, and her boss's boss, who's a director who reports directly to the 2 founding CEOs, are all women. So her chain of command is all females. And the idea that they would serve her up for any kind of pretextual, fake, made up performance considerations is going to be a very hard sell for them. The 2 female bosses were very, very involved with everything that happened next. And Dean, again, being a lateral to her, had no say over it whatsoever. And her bosses don't have anything to do with Dean either. He's on sort of a different track. His boss's boss is a female also. His direct boss is a male.
All right. Well, all right. I hate to say it, but in group and figuring out how to go along to get along is just not going to be hard for people to understand. That sometimes women have to
maybe not.
Okay, so one other thing to talk about is how we want to share the report, what we can share. I get that it's privileged and that the general counsel was the person to direct it, but let's think about what you want to share, what you can share. In the meantime, I will let you know that Andie shared with me that they have declarations from people that are going to really corroborate Chelsea's version of events. Now, I'm not at liberty to share really the specifics of the declarations, but I can tell you that I've seen them, and they're something that you're going to really need to contend with. One of them is a former employee, and another one is a current employee. I know you'll be able to, get these. You'll be able to assess their credibility when the timing's right, but they're not ready to share with you now, but know that they're out there. Okay, so let me find out throughout the day how much more we can share on that, and we'll work through this as the day unfolds. We're a few hours in. I do want to get back to Andie and get the ball rolling on negotiations. Their opening demand was 2.5.
So it's the old saying, a picture's worth 1,000 words is now a picture, and a video is 2.5 million words. Is that where we're at?
Well, I mean, it was a live photo, so, yeah.
video, text, whatever you want to call it. Two communications is now 2.5 million. I guess that's inflation and the cost of living adjustments or something. The company would never voluntarily pay that, or involuntarily if they even could. They don't have insurance for this. So the company recognizes there's no arbitration given the harassment allegation and the EFAA amendments to the FAA. More likely than not, unless they plead it weird. But we recognize this is public record. We recognize this is filed. I would assume they told you that they'll file it tonight. They'll e-file it tonight if we don't settle or something like that. They don't really care. Our client doesn't really, fine, go file, and years will pass and appeals will come, and 5 years later, we'll be back to you again. So they don't have any fear or concern of that threat. I've worked with Ms. Fields before. I guarantee you it's ready to go. And I told our clients that, and I said it'll be probably every cause of action you can think of, and all kinds of other stuff that that will be thrown in. On the declarations, real quick, I can tell you that I've never seen them. I've never heard about them. The investigator, having reviewed the report, talked to everybody in the vicinity and everybody that they were told to talk to. And there were several people who refused to talk to the investigator, including 2 or 3 former disgruntled employees. And so I could probably identify whoever this magical fake, confidential declarant is, because there have been people who've left for performance reasons, misconduct, and other things, dead to rights, who are bitter and bent out of shape because of their exits. Now, obviously, there would be a whole debate about, timing and Me Too and the vet credibility and discovery and depositions and subpoenas and everything else. I did not know that, and I will certainly, my client is here and we'll certainly discuss that in the next go round. That happens pretty often. It's not an uncommon thing to have some kind of statement or declaration or writing from somebody to say, I didn't like the guy either, and he was a lech, or I saw something weird, or in my opinion, somebody was a little too, close for comfort, etc. But that obviously is something we have to talk about. We did not know that until 5 minutes ago.
But Eric, I mean, yes to everything you said, and I do appreciate that you are very intellectually honest about the fact that having declarations, having other people, even if they're disgruntled and former, really feeds into this culture that Andie and Chelsea are really pointing to, right? That this is a boys' club. This was very hard for women. She thrived until Dean set his sights on her, right? So those declarations will make it muddy in that way. So I think you're taking. I only say that to say it has been half a day in talking through this. We should try to get the numbers going to see if we can't close the gap right now that we have to try to resolve this in a way that allows AIT to focus on its business. AIT, I understand, as you've shared, thank you. They think Dean is a keeper with the company. So I want to help you all figure out how to do that. I think that Chelsea is, as much as she says, ready to come back. I don't know if you want her back. I don't know your thoughts on that. But if we can, by the end of the day, get to a number that allows the company AIT to focus on its growth, putting Dean in a place so that he can succeed with enough guardrails around him so that, you never have to face this type of risk or exposure again. The AIT doesn't. And that Chelsea gets a chance to move on. I know 2.5 is a big number. That's a starting number. That's obviously not an ending number. So what are your thoughts on a counter?
My thoughts are they're never going to give her 10 years pay for this incident, no matter what. Because essentially that's not quite 10, but it's 9 and change.
Well, okay.
I mean, essentially based upon her base salary,
yeah.
It's essentially a 10-year ask. And nobody's ever going to go for that. I can tell you that the company is here in good faith. They're willing to negotiate. The way I do these negotiations is they tell me what they want to pay, and I don't do less than what the maximum authority is on each round. What I would say is okay, so the ridiculous demand is faced with the insult number, but we're pretty far into this, and I don't think that's going to be productive. I could come back with 10 grand, and we could play that game for their 12 hours. And I don't think, and I say in some instances you have to do that, because it's just so outrageous. If she said 25 million, we would have said $1,000, and 27 rounds later, we're probably here. So I've been authorized to offer 50, which is essentially several months' pay. And that's all I have. And my clients are here with me. And if they will authorize more, it's a starting point, but it's never going to be anything approaching anything. I don't know where we land, but I could tell you that their take on it, most likely than not, is not going to be anything remotely into not even close to 7 figures. So I don't know where it lands, but they're here. We'll get we'll either walk out next and we'll go home early, well, sort of early, or I'll have something more for you. But I think that, I have one question. If we do settle with her today, one thing is definitely going to be a part of this is that she has to resign. They're not going to pay her and keep her and then face another retaliation lawsuit based upon people not saying hello or saying hello weird or not having her on an email chain or any of this sort of passive aggressive retaliation that you're starting to see with, the implicit bias kind of things. They're not going to do that. They don't have the time or the energy to be, I didn't get invited to birthday lunch, so I'm being retaliated against. So she's going to have to go. And if she's not willing to go, then this may stall out right here. But if she is willing to go, and there are probably some other things that go with that, then we certainly will have a conversation.
Okay, great. I get it. I will make sure that we get that term on the table. Okay. Thank you, Eric.
Okay, so I'm getting booted now.
You're getting booted. Yep.
All right.
Bringing Andie back.
Hey, MyKhanh.
Hi, thank you so much for your patience. I know I've been gone for hours and hours, and we're now at something late in the day.
Well, hopefully you have good news for me.
Well, I have clear willingness on the other side to work towards a resolution that puts all this behind Chelsea, behind the company, and allows everyone to move forward. I want to confirm that does mean a resolution that comes with a resignation from Chelsea or a separation in whatever form that you want her to separate. That's Chelsea's understanding, and she wants that as well, correct?
Well, I think that actually kind of plays into our argument that their claim that she's welcome back isn't actually so much of a welcome. I think that, while she willingly took this leave to focus on her mental health and to get well, it was very clear that they didn't want her there anymore, which I think directly feeds into our retaliation claim. So, I have talked.
Let me just pause you for 1 second, just 1 second to say that this is in the context of this settlement and this mediation, right? And so I really want to think about, could they make it work that she comes back, and would they do that? I think they would. If we don't settle, if you all don't settle, that door is going to be open for her. But I really want to focus on what Chelsea wants, and if she wants the chance to move on, let's pull them up and get the best deal on the table that we can, that it will allow her to do that. I totally get how introducing the resignation could feel like it's part of the retaliatory scheme, but this is something that, is very much in the context of this settlement discussion.
Understood. I think we can agree to disagree on that. I think that, this kind of does feed directly into the retaliation because she didn't feel like she could be there and doesn't feel like she can return, especially after having been treating for quite some time now. And so she is willing, but they are going to have to pay for that. Not to rehash what's in our brief, but her LOE is high. She was an early employee. She was granted over 300,000 in equity, which she'll lose on vesting if she doesn't stay. She was a $250,000 a year employee. She made a 25% bonus, which she got each year that she's been there. So they're looking at upwards of, almost $600,000 in LOE. So as long as they understand that, if we're going to agree that she leaves, that she needs to be set up for success on her way out.
Okay. Yes. I mean, right now I have to tell you, they are struggling to see this case in the six figures at all. They have a $50,000 counter.
Okay.
And so it's going to take a lot of work to move them into the six figures. But we need to keep working on it. We need to keep working on it. And if it's the case that obviously she hasn't suffered any loss of earnings yet, right? I mean, she is still on leave. So if her LOE is 600,000 and this involves a settlement involves her leaving the company, that will change the conversation in the other room. And so I will bring that up. We're very late in the day. It's been somehow already 5 hours or so. We are at 12:45, which is towards the end of our day. So how would you like to counter? Give me a counter so that I can go to the other side, get a little movement, and then maybe you and I could be talking about whether or not you would want a mediator's proposal and whether or not that's something that we could be working towards.
Well, I'm happy to give you a counter, but I think I also need to give you a little more ammo when you go back into the room. I think you need to share a little bit of the details about Sarah's declaration. Make them aware that we're aware that there was an previous HR complaint specifically about Dean and that he was allowed to continue to work there, that they knew this was happening and that he was doing this behavior and that this is happening again. And I guarantee Eric's going to say, oh, she left on bad terms, et cetera, et cetera. But these two aren't the only two declarations I'm going to get. These are just the only two I have for this mediation today, and there are more coming. So I think they need to understand the value of that. I'm happy to go make a good faith offer and, go down to 2 million. And, hope that they recognize that we're here and that we are making moves and, we're here in good faith. And I hope that they realize that there's real liability here and that this is not going to look great in front of a jury.
Okay.
With
No,
that, send you.
No, I appreciate that, and I will go. You know, they understand. And I am hammering home over in the other room in the last hours that you see this as a seven-figure case.
Right.
They get that. They get that the discount gets you lower into the seven figures, and that you're not thinking about this as discounted into the six figures. So I think this is a good move. Let me go over there. Let me share more of the. Did you say I can share at this point Sarah's name, just not John?
I think the content is really what needs to be shared. I think keeping both of their names confidential at this point. I mean, Eric's a smart lawyer. He'll probably be able to put two and two together who Sarah is. But for John's sake, I think it's really important considering he's still there. But I think a bit of the content might really move the needle up into the six figures, which is where we need defense to be to get this, to get the ball rolling, to get this done in a reasonable amount of time.
Okay. All right. Thank you, Andie. I'm going to move you out of the room and move Eric back in.
Thanks, MyKhanh.
Hey there.
Hi, Eric. Have you ordered dinner? I know it's late in the day. What is it, 8 p.m.?
I don't know. I blacked out hours ago, so I have no idea what time it is.
9 p.m. Maybe grab something downstairs because I think there's going to be a lot more work to be done. They're still very solidly in the seven figures. They are very, very emboldened by these declarations that they've gotten. They've gotten the two. They're very confident, based on their investigation thus far, that there are going to be more declarations that show that Dean has been engaging in this flirtation. This is not a one-off event. This is something that management has tolerated, given how productive he has been, given how profitable he has been for them. And so this is a choice that they're choosing to keep him for his for the revenue that he generates, more so than protecting the people within the work environment. And so they're still in the seven figures. I'm pushing on them. I've let them know that you feel very strongly that this investigation was thorough and it was done by a third party objectively, and you or the investigator made sound findings that the company took action, and there has been no further misconduct or any allegation of misconduct after the investigation was done. So they get that. Listen, I confirmed that this, if we can resolve this today, this would be with a resignation from Chelsea. She would be, that would be the end of her vesting, right? So all outstanding equity would, the vesting would be waived, and she would leave the company, and it would be a clean break. So there's a lot of value to that as well, because the way they calculate it, I mean, she easily has a $600,000 of loss of earnings as a matter of separating from the company, and that it would take her time to land another job after she recovers from the emotional distress of what she suffered from the company. And I know, Eric, this is all hard to hear, and it's all going to be hard for AIT and that leadership team that really prides itself on having done everything right to hear. I get that, but I also understand that they want to resolve. So I want to get your thoughts, and I want to get your thoughts on, given how late in the day we are, if a mediator's proposal is something that you would invite and that you would want to consider, in which case we should feel out. I can tell you what I think the range would need to be for it to be seriously considered in the room. And I want to get a sense from you whether it would be something you would recommend to your clients.
So I can tell you that I'm certainly not the smartest lawyer on this Zoom or in any of these rooms, but we think we figured out who this secret declarant is, and we are absolutely confident that we will demonstrate that her departure was absolutely defensible and that she never cooperated in the investigation. We had 17 people interviewed who would cooperate. We had 5 or 6 or 7, I can't remember the exact number, who did not and would not, or even respond. We had some people respond, I don't want to talk to you, and we had some that did not respond. The person who I'm confident is the declarant did not respond to several inquiries to communicate with the investigator. So whatever she's going to offer, she didn't tell us, and we didn't get to take that into consideration. Equity vesting, bonus, future loss of earnings is massively speculative. You know, there's several years to go before those shares vest, and what the value of them in that time might be is really hard to say. You can't really do much with that. 2 million is still way too high. I don't know if we're at a proposal yet. I think we need to grind a little further. My clients have expressed that they are reluctant to even get into 6 figures still if they're not going to really make a big move. So I like to do my negotiations based on real numbers. So 6 months base pay on what I believe is about 187.5 is 93,750. So they're willing to give her 6 months pay, which basically makes her whole on the time of her leave, gets some money in Andie's pocket, and gives her a little bit of flex on the back end for future looking for a new job. And they would also consider leaving on the insurance, you know, for Payner Cobra or something along those lines. I will relay the offer of the shares back, because I guess they would be buying them back essentially. I mean, I think is what that part of it is. I don't think they get waived because they've been issued. So I think they're bought back at some valuation. I don't know what that would be, but that would be a further separation of the relationship that I think they would value. So that's all I got right now. But these are economic factors that may or may not be considerable for them.
Okay, so at this point, if we're trying to figure out what the number is, right? That gets this wrapped up for AIT, where equity, there's no more vesting. There is a complete departure from Chelsea. That is going to that's going to really require AIT to be well into the six figures. I don't know if I could pull Chelsea down into the six figures, but if I could, and if they would be willing to consider something in the 900 range, I think that's what it would take. And so that's what I guess my question to you is, something that you would take to AIT and discuss. Because if not, I think we hold off on the mediator's proposal. The consequence would be Andie and Chelsea are going to file, and then this will be litigated. So is there a window right now where I get, Eric, from your perspective on the legal case, you'd want to take this case every day of the week, but with everything
Not really.
else
I have
on the
plenty to do.
table.
I don't need this case to keep my lights on. They just turn off by themselves. But
Okay.
I don't need this case to keep my firm afloat. So, oh, my lights did go off though. That was
Okay, there you
excellent.
go. On cue. So that's my impression of what it in the other room that it would take at this point. That this case is not going to be discounted down below the, I don't know, below the million range. But if so, they're going to hug that line, and it's going to be in the nines. So
So I can tell you that I'm not sure they would go. I'm quite certain that they're not going to pay $1 million. I could tell you that if the equities, if all those other factors are put in to whatever because I don't know what they valued it at. We probably need to go back and forth a few more times to see if we can grind this down. But I'm very confident that if they're not presented with $1 million, but I can tell you what the comments have been from about the 6 people who are the decision makers, which is there's no way we're not paying $1 million for one incident, and they're not going to pay $1 million to to give the plaintiff essentially $600,000 pre-filing. Again, you're talking years and years of compensation for this. Even if she leaves and all these other things. However, if they were faced with it, I think they would consider it. But I don't think if it was $1 million, they would do it. I think that the psychological impact of that, especially since you're telling me there's this Me Too person out there who has been gone 2.5 years, but that does not mean that there's other claims that can be brought. So her exhaustion time hasn't passed on a FEHA claim of 3 years. So they're going to spend 6 months wondering when Andie's going to come calling again. And that's a huge factor in this.
okay. All right. Well, you would have confidentiality provisions, you would have liquidated damages provisions so that the amount of settlement would be all locked up. Think about the terms that you and AIT would need to have in a media proposal, and then let me come back to you because
Yeah, I would say it's all this. So just to do it now, it's all the standard, mutual waiver, 1542, confidentiality, liquidated damages of 10% of the settlement, non-disparagement, cooperation in litigation, notification if she were to, be subpoenaed by somebody else, that kind of. There's nothing. I don't think there's anything out of the ordinary. And then, however, the structure of the shares would be, which I don't know right now, but she'd have to work with us to find because that's not what we do, issue, those types of transactions. But they're still here. They're dying of exhaustion and a very long day, but they're still sitting here listening. So
okay, well, you get to go deliver them hope that there could be a deal that could be had in that 900 range. So let me go talk to Andie, and I will come back to you.
Thanks.
Okay, bye, Eric.
Bye.
Andie. Hi, Andie.
Hey, MyKhanh, it's late.
It is so late. Thank you for your patience. Please know that we're over there having a lot of lively discussion with Eric. They just do not see the case at all the way Chelsea does right now, right? And so some of this is how much litigation, how much discovery might be needed to get to the range that you're thinking. That being said, think there is a real desire for closure here, and I'm getting that sense from you that there's a desire for closure for Chelsea as well, or that Chelsea has. They still see the case, if at all, in the six figures, in the low six figures, but given the separation, given that a settlement would come with a separation, given that it would come with the value of the equity, I think there is some openness to a mediator's proposal. I'm getting the impression there is no mediator's proposal in the seven figures that would be accepted, in which case, if I don't think that there's a proposal that's going to be accepted, I'm not going to make it. And if I am not invited to make one by both sides, right, and that you wouldn't also get behind the number, I'm not going to make it because I know Chelsea trusts you. And so your recommendation will mean everything to her. Given what she wants to accomplish, not just today, but in her life, right? The question is if we could get them up into the 900 range. It's not seven figures, but it is a substantial, it's close. It's close. Is that something that you would recommend to her?
I think that, it'd have to toe really close to the $1 million line. I'm guessing they have psychological issues with $1 million.
It's that mythical milestone, right? Yeah.
Yeah. I mean, I understand. I think, if they're willing to do a payout, we'd need some of the non-monetary terms. We'd want mutual non-disparagement. We want to make sure that, she's not being trashed in the community. She is going to need to get a new job. She's 32 years old. She's going to be in this area. She's a bright star. She's going to need to be here. We're going to need a neutral job reference. I'm sure they're going to want liquidated damages, but if you can bring me something in the high nines, I will recommend that to my client.
Okay, thank you. All right, I'm going to say goodbye to you for 1 second. And I am going to address. Oh, hello, Eric. I'm not ready for you completely yet. Okay. All right. So I was just going to say to the audience really quickly that we have tried to simulate what we could of a full day. This would take a lot more time for us to discuss so that both counsel feel comfortable that they would recommend a number. Because again, I'm not going to make the mediator's proposal unless counsel recommend it. But we assume then that we get to a number that they both feel confident would be a number that would work. I would explain that they're double blind, that I will make the proposal, and if both sides say yes, then I tell them they have a deal. If one side says no, then I say no deal without disclosing which side said what. And even if a mediator's proposal is not accepted, that doesn't mean the end of it. We keep working until we keep working at it. That being said, and for the purpose of this mock mediation, I'm going to bring Eric back in to ask him I'm going to present the mediator's proposal at $950,000 with all the terms that you laid out: confidentiality, separation, liquidated damages on the confidentiality, all that. Eric, do we have a yes or no?
Our client reluctantly, painfully, excruciatingly, unpleasantly accepts a 950 with the terms for reasons 98% not related to Chelsea or Dane.
Okay, well, I'm glad that you were able to bring them such a potentially positive business solution. Give me 1 second and I will let you know what the response is.
Okay, thanks.
Okay, Andie? After careful consideration, and now all rushed for the purpose of this mock mediation, I'd like to present Chelsea with a mediator's proposal of $950,000 with terms that you and Eric will work out, but they're standard terms and include her resignation and a confidentiality provision with liquidated damages. Would you accept or decline?
Yes, my client accepts.
All right, Andie, Eric, can you both come back on? This is very compressed. Congratulations. You both have secured a resolution for your clients, and they are both able to move on with their lives and put this behind them, thanks to your excellent advocacy and collaborative problem solving. So congratulations.
Thank you, MyKhanh.
Thank you, MyKhanh.
Thank you both.
Thank you so much, everyone. We have to conclude our program, unfortunately, but at the end of this webinar, you'll be prompted to fill out a survey. If you could just take a few moments to fill that out, that is wonderful feedback for us going in the future. But I do want to thank our speakers, MyKhanh, Andie, and Eric, for such an amazing program. I hope you all enjoyed it. And if you have any questions, I know we don't have time right now, please feel free to email any of the speakers. We will give their emails when we send out the certificates within a week or so. But thank you all again so much and hope you have a great rest of your day.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.